what is required to be a buyer in the ordinary course of business? So in a previous video we talked about the priority of a purchaser of collateral that is subject to a security interest. And we stated that a buyer in the ordinary course of business can buy collateral that is subject to a security interest, and they take that collateral free and clear of the security interest. But certain conditions have to be met. They have to meet the requirements of a buyer in the ordinary course. The main requirements are, first, that the buyer has to purchase it in good faith. That is, the buyer can't have an intent to deceive anyone or to defraud the secured party, for example, by purchasing the property. So these shell transfers of property around would not create a buyer in the ordinary course. Say the transfer is just intended to defeat the secured party's security interest. That won't work. It has to be in good faith. The buyer cannot have any notice that their purchase violates another party's security interest. They can be aware that the security interest exists, but they can't know that it in some way violates the authorization, that is, the sale of the property is not authorized or somehow violates the rights of the secured party. They have to believe that the sale of the property is authorized. Generally, they have to believe that they're going to be a buyer in the ordinary course. Otherwise, they wouldn't purchase it. And then they have to purchase it in the ordinary course of business. That is, the seller of the collateral regularly sells goods of that kind. And pursuant to that, the buyer buys it, right? Under the assumption that the seller is selling a good of the kind that they typically sell. So if all of those conditions are met, no notice of the defense, good faith, and purchasing it in the ordinary course of the debtor's business, then the purchaser will take the collateral free and clear of the original secured party's